with us, and he's going to talk about some of the legal aspects in delivering justice to the victims of Grenfell. Thank you.
It's like one of those self-help groups, isn't it? I must declare, I admit I'm a lawyer. I'm dealing with it. I provisionally entitled what I want to talk about this evening is simply Grenfell doing it justice. And what that really means is finding out what truth is. And that word truth must ring through every adjunct that we use in the law to actually investigate, analyse, and try and work out what went wrong and what can be improved in the future. And I suppose one of the critical questions as far as the law is concerned, and I want to deal firstly with the strict confines of the law, then I'll go a little more wider than that, is can the law, is what we've got equipped to get to the truth? There are four ways that the law provides that ability, if it is indeed an ability. The public inquiry, the coroner's court, the criminal courts, and the civil courts. And these courts are going to be tasked, and we are going to be determined to make them understand it at each and every opportunity, that it's the truth we want. But what is the truth? And I think it's important to define that question before anything starts at all. Now you'll all have your own views about what the truth is, but let me start the ball rolling for discussion. This is my stab at it. The truth is finding out why there has been a systemic breakdown of policy and provision of safe and habitable social housing, to include procurement of contractors and materials, strategic decisions made both locally and nationally, and the adequacy or inadequacy of ongoing monitoring of work and safety in such buildings. That's the truth. But it goes further, I'd say, than that. The truth is finding out why prior warnings and complaints and other observations about dangers relating to Grenfell and other similar social housing on a local and national scale were ignored. That's the truth, trying to find out answers to those questions. And the truth is examining the effectiveness and efficiencies of the response of local and national government in the face of the tragedy that occurred. Now, those truths we've put forward as being important elements of the terms of reference of this forthcoming public inquiry. Others are doing the same. And when I heard the judge of the inquiry immediately within hours of being given that appointment, immediately purporting to rule out a broad inquiry, to put it mildly, my heart sank. I'll come on to the public inquiry in a moment. But how dare he say that at such an early stage in the inquiry, when surely he'd not had an opportunity of maturely reflecting upon what the needs and requirements of that quest for truth, which is, after all, surely at the central core of any inquiry, dictates. And so, it is important that we obtain the truth within the public inquiry, within the coroner's courts, within the criminal courts, within the civil courts, for accountability, for transparency, and for lessons that must be learned, and for justice to be done to those that have lost their lives and people they've left behind. It's important also, and I know that people here that have been so affected by the tragedy know this, but it's important that when it comes to lawyers and others working in this area, that we remember that although we as lawyers, and know that people here who have important contributions to make about the way forward, remember that the real world is the people affected at the moment have funerals to arrange. They've lost their possessions. They've lost their homes. They are displaced. Their lives, those that have kept them, have been disrupted to such an extent that many of us, including myself, can only imagine. And that is the background to our discussion here. And we're having an important discussion, bringing together people of like mind and different contributions to make. But let's remember that that is in the background to all this. Justice and the truth can never fully compensate for that. But the fight for justice will take place. It will be long and frustrating. But the public inquiry is here. And we must use and utilise that public inquiry for all its worth. But already I have concerns about the composition of that inquiry. I, in fact, am not calling, it's personal, for the judge to resign now. Notice the word now. It is important to work with the structure that we've got, but my goodness me, when I see 3 barristers appointed to assist him, one with tremendous burden enrichment of criminal experience, but the other 2 able people of integrity, but corporate lawyers. I worry that 2 corporate lawyers of extreme ability and integrity are going to assist a corporate judge with one excellent choice of a criminal barrister. But he goes further than that. You know, under the Inquiries Act 2005, ministers, and particularly the Prime Minister, has the power under Section 3, under Section 4, and under Section 11 to appoint additional panel members of expertise and diversity to balance off the experience of the judge. Under Section 11, ministers have power to appoint assessors, people of experience and expertise, to advise the panel. I've not seen any of that yet. And so when we're discussing, in my view, the public inquiry, the questions that should be asked right at the top of the list is that we have power to make this inquiry inclusive, we have power to make this inquiry diverse, we have power to make this inquiry a group of individuals with the wide ranges of expertise needed to get to the truth. And we haven't got it yet.